Good morning, folks. It's Andy Stautz at Stautz Law. I'm back for another talk about an estate administration topic, a probate topic. Today we're talking about spreading the will of record, which is also called probate of will without administration. So what is this? What are we talking about here? This comes up when you have a small estate, usually. So in the Indiana probate code, you've got full formal supervised administration. You've got unsupervised administration if you need to do some uh, some court involvement, but not quite as much. And then you've got dispensing with administration, which means you don't do any administration at all. And that happens when the estate property is below the threshold, and right now that's at $100,000. So if you've got a small estate, you don't need to go through all the formal probate processes. But if there's a will, you've got basically 3 years to probate the will. Now there are tons of exceptions to that, but that's another topic. So if the decedent left a will but also has a small estate, but you want to give effect to the will, but you don't want to go through all the administration. That's what spreading the will of record is for. That's what, probate of will without administration. Basically, you take the will to the court and you say, look, here, this person left a will. We don't need to do anything with it because we're doing the small estate procedure, which is really informal. But put it on the books, recognize that it's valid. That way we've got it later in case anything comes up. And it's kind of, it's just a precaution, kind of just a way of making sure it's on the books before the time's up. That way, if there's any question about it, it's there. You're not trying to dig for it years and years later. It just kind of answers the questions. Good best practices. And it's really easy. It's basically just a petition to the court. This person died. Here's their will. We think it's valid because, it's witnessed and there's a self-proving clause. And the court looks at it and says, yep, okay, go for it. And then you just carry on doing whatever the small estate administration is in that case. No further action needed. So that's just kind of one piece of the total small estate procedure, which I will talk about in a different video because it's lengthy. But I think the one other important thing I need to note here is this. The small estate procedure applies to probate assets. So it doesn't mean that the person was flat broke. It means the person was either flat broke or did some good estate planning, like maybe a revocable trust or beneficiary designations or something such that there aren't probate assets. Doesn't mean there are not any assets at all. So, spreading will of records, really common for a pour over will that you're using in conjunction with a revocable trust, right? Because everything's in the trust, the probate assets are below the small estate limit. You've got a will because, just to catch anything left over. So you spread it of record. That's a really common use case. The other would be, even with less advanced planning, maybe you've got a transfer of death deed for the house and a couple retirement accounts with beneficiary designations. Again, it's not very fancy planning, but the probate assets are minimal. So, you've got a will as a backup. You probate it without administration. You spread it of record, but everything else is going outside of probate. So that's kind of the procedure. That's how it works. It's easy to do. And like I said, it's common in certain scenarios. A true small estate, an estate that's small because everything's in a trust, an estate that's small because everything's handled with transfer on death designations. But easy to do. If you need help with it, call me or book your appointment online. Like I said, this is a very routine thing to do, and hope this talk has helped you understand what you're looking at. Thanks and bye for now.